Jesse Outley. On August 29, 2021 in Syracuse, New York, 22-year-old Jesse Outley was involved in a shooting that claimed the life of Dior Harris, the youngest victim of gun violence in the city's history. Outley and another man had been targeting a vehicle when gunfire erupted, striking Dior as she sat in the back seat. She was rushed to the hospital, but did not survive. The senseless act devastated her parents, Des and Andres, who lost their daughter. Outley was arrested and charged with murder, facing trial in Onondaga County Court. Emotions ran high throughout the proceedings, with Dior's parents addressing him directly. Through their grief, they told him he had stolen their world and that he could never understand the pain of losing a child.
You get to see your people! We can't see ourselves!
You don't understand because it's not you. If you had kids, you understand, man. You understand, yo. 4 days before 15 days before our first birthday, man, clown took over because they want to shoot up the wrong car, man.
During sentencing, tensions in the courtroom spiked when the judge ordered Outley removed after he appeared to smirk in the face of the family's anguish. When he returned, the judge spoke firmly, acknowledging that no punishment could ever balance the weight of such a loss.
You get to see your people! We can't see ourselves!
You don't understand because it's not you. If you had kids, you understand, man. You understand, yo. 4 days before 15 days before our first birthday, man, clown took over because they want to shoot up the wrong car, man.
In March 2024, Jesse Outley was sentenced to 40 years to life in prison. Despite his young age, the judge emphasized that his choices had left a permanent wound on the community. For Dior's parents, justice had been served, but nothing could ever bring their daughter back.
I feel great. Such a relief. I don't have to be humiliated. I finally have justice for my baby. Long live Dior, justice for Dior Harris. You know, that's all I wanted from the beginning. I'm upset that it took this long, but it's finally here.
Her death remains a painful reminder of the toll of gun violence in America and the lasting scars it leaves behind. Anna Marie Jatani. On March 14, 2021, 38-year-old Anna Marie Jatani was at her home in northwest Bazar County, Texas, with her husband, Tony Jatani. What began as a domestic dispute turned violent when Anna retrieved a kitchen knife and stabbed Tony 17 times. Neighbors called 911, and emergency responders rushed to the scene. But according to the police report, Anna continued stabbing him even as paramedics arrived. Tony Jatani was pronounced dead inside the home. Hours later, Anna was arrested and charged with murder. In 2023, Anna accepted a plea agreement and appeared in court to face sentencing. She pled guilty to the stabbing death of her husband, and the judge accepted the deal, sentencing her to 25 years in the Texas Department of Corrections, along with a $10,000 fine. During the hearing, Tony's parents delivered emotional victim impact statements. His father, Alfred Jatani, spoke directly to Anna. The family told the court that the pain of losing Tony could never be healed. Anna sat quietly as their words were read, offering no response.
I wish terrible things to happen to you in this life. When you die, you should burn in hell forever.
I will all the time pray God that you rot in your prison cell.
Under the terms of her sentence, Anna Jatani must serve at least half of her 25-year punishment day by day before becoming eligible for parole. Her conviction brought closure to a 2-year case that left a family grieving and a community shaken by the brutal violence inside a marriage. Christopher Schultz. On a sweltering summer afternoon in Tucson, Arizona, Christopher Schultz returned home with his infant daughter in the car. It was June, and outside temperatures had reached 109 degrees. Investigators later determined that the car shut off automatically after 30 minutes, leaving the baby without air conditioning. Schultz admitted to police that he often left his children in the vehicle. That day, he became distracted by a video game and by putting away groceries. Hours passed. Around 4 p.m., his wife, a medical doctor, arrived home and asked where the baby was. Schultz searched the house before realizing she had been left inside the car. By then, nearly 3 hours had passed. Neighbors' surveillance footage confirmed the family had returned at 12:52 p.m., far earlier than Schultz had claimed. When the child was finally pulled from the vehicle, her mother desperately attempted CPR, but it was too late. Paramedics rushed the little girl to the hospital, where she was pronounced dead. In the aftermath, text messages between the couple revealed a troubling history. His wife wrote, "I told you to stop leaving them in the car. How many times have I told you?" Schultz replied, "Babe, I'm sorry. Babe, our family, how could I do this? I killed our baby. This can't be real." Investigators also discovered that Schultz's other children told police he had frequently left them inside the vehicle in the past. Schultz was arrested and initially charged with second-degree murder, but a grand jury later upgraded the charge to first-degree murder, which requires proof of premeditation and deliberate action. At a Pima County Superior Court hearing, Officer Michelle Meyer read the upgraded charge aloud as his attorney entered a not guilty plea. The court has not yet set a trial date. If convicted, Christopher Schultz faces life in prison. Under Arizona law, the death penalty is possible, though officials have stated it will not be pursued. Michael Hernandez. On February 3, 2004, 14-year-old Michael Hernandez lured his classmate, Jamie Goff, into a bathroom at Southwood Middle School in Palmetto Bay, Florida. Once inside, Michael stabbed him more than 40 times, killing him instantly. He was arrested later that day and charged with first-degree murder. At trial, prosecutors described the attack as cold and premeditated, pointing to Hernandez's personal journal where he had written out detailed plans for the killing. In 2008, Michael Hernandez was convicted and sentenced to life in prison without the possibility of parole. But in 2012, the United States Supreme Court ruled that mandatory life sentences for juveniles were unconstitutional. His case was overturned. Hernandez returned to court for resentencing in 2013, now 25 years old. His parents appeared in support, while the family of Jamie Goff prepared once again to face the young man who had taken their son's life. As he left one hearing, Hernandez even blew a kiss to his parents, a moment that struck many as unsettling. Judge John Schlesinger scheduled a new sentencing hearing for August, setting aside 3 days to determine Hernandez's fate. His defense highlighted his time at Columbia Correctional Institute, where he had worked as a law clerk and pursued an online degree. The Goff family offered no public comment at that stage, though in earlier statements they had said they forgave Michael for Jamie's death. Ivonne. On September 23, 2023, 27-year-old Ivonne, the ex-boyfriend of Coral Nino and the father of her child, walked into a Houston police station and confessed to strangling Coral after the two had been out at a bar that night. Investigators said they returned to her home, and during a conversation outside, an argument escalated. Ivan admitted he put his hands around her neck and killed her. Afterward, he drove her body to the parking lot of an Academy Sports store off Highway 290 and left her inside the car. When he surrendered the next day, police discovered he had a bus ticket to Mexico in his possession, raising concerns he had been planning to flee. Coral's family described her as a young mother trying to build a new life without him. While Ivan's jealousy lingered, she was just 27 years old, and her family now faces the painful task of explaining to her young son why his mother will never come home. Ivan was charged with murder and booked into the Harris County Jail. His bond was set at $150,000. While the legal process moves forward, Coral's family has created a donation page to help cover funeral expenses and provide support for her child. Ivan remains behind bars awaiting trial, while the community mourns the loss of a young mother whose life ended in violence. Joshua Amburgey. On June 14, 2023, 42-year-old Melissa Amburgey was at her home in Ohio when her eldest son, 22-year-old Joshua Amburgey, attacked her in a brutal stabbing. Prosecutors said Melissa was a devoted mother of 4 and grandmother of 7 who had built a life with her husband Ted over more than 4 decades. But that life was shattered when Joshua picked up a knife and repeatedly stabbed his own mother. After the murder, he also assaulted a responding police officer before being taken into custody.
Shots fired, nails down. Lay down! Lay down! Hey, I need a tourniquet and gloves. I got one. Tourniquet and gloves.
Every officer has a tourniquet. University of Cincinnati Air Care passed that word back that had the tourniquet not been applied, he would not have made it.
Joshua later pleaded guilty to aggravated murder and felonious assault. At sentencing, the courtroom was filled with grief and anger as Melissa's family addressed him directly. Their words made it clear. Their relationship with Joshua ended the moment he committed the crime. Prosecutors urged the judge to impose life without parole, stressing the fear he created for his entire family. Despite those pleas, the judge sentenced Joshua Amburgey to life in prison with the possibility of parole after 41.5 years, meaning he will be 81 years old before he is eligible for release.
We are glad that he got what he got. I think just to start a new, fresh chapter, that's what my mom would want. So,
I think I feel a little bit of relief that this chapter is over, and I think we got some justice today. So, that's how I feel for my mom. So.
After today, I am definitely feeling grateful and relieved. We definitely needed this moment to be able to restructure our lives and move forward.
Cynthia Varela. In December 2013, Cynthia Varela Casas was charged in the death of her young son, Omar Varela. Prosecutors stated that Cynthia repeatedly kicked Omar, causing fatal injuries. The tragedy shocked the state and devastated the family. At trial, Cynthia pleaded guilty to 6 counts related to the killing, admitting that she had kicked her son to death. She claimed it was an accident, that she had been trying to discipline him, but her words did little to ease the pain inside the courtroom. During sentencing, Omar's aunt, who had adopted him and his 2 younger siblings, spoke of the lasting trauma the children carried. She read aloud how Omar's sister often asked why her brother could not be fixed and why she could never hug him again. In a heartbreaking moment, Cynthia's own daughter pleaded with the judge to keep her mother in prison, saying she feared her mother might hurt her too.
It's hard to block out, now that everything has come to light, how he was treated and what those people did to him, his mom, his stepdad, how they talked to him. And I can only imagine the worst, and I'm trying not to do that because I have to stay focused for him. It's unreal. I guess I don't feel like he's gone. I feel his presence in my home every day.
The judge ultimately sentenced Cynthia Varela Casas to 40 years in prison and ordered that she have no contact with her surviving children or their guardians while in custody or on probation. Omar's stepfather, Steve Casas, was also sentenced to 30 years. Eric Nos. On February 12, 2015, 19-year-old Eric Nos of Las Vegas, Nevada, became involved in a confrontation that ended in tragedy. That night, 44-year-old Tammy Myers, a mother of 4, was out driving with her daughter when tensions escalated. Later, near her home in a quiet cul-de-sac, Nos opened fire, striking Myers multiple times. She was rushed to the hospital, but 2 days later, on Valentine's Day, she died. The shooting shocked the Las Vegas community and left 4 children without their mother. Police arrested Nos just days later, charging him with second-degree murder with the use of a deadly weapon. At trial, the courtroom heard raw and emotional testimony. Tammy's children described their mother as their best friend, sharing the pain of holidays without her. Her husband, Robert Myers, told the court he had lost his wife of 24 years and the grandmother of his grandchildren. He called Nos an animal and said he would never forgive him.
She's looking down today. She's been vindicated today.
Is this finally over for your family today?
I don't think it'll ever be over. We're going to miss a great woman, a great wife. That won't be over for us, but the part of this will be. Come forward and say their piece, They've got a lot to deal with in their future, a lot. It's not going to be easy for them.
The defense argued for leniency, but the judge stressed the danger Nos created by opening fire in a neighborhood full of families. After lengthy proceedings, Nos accepted a plea deal. In 2016, he was sentenced to life in prison with the possibility of parole after 10 years, plus additional time for weapons enhancements. He was also ordered to pay restitution. Before sentencing, Nos addressed the court, asking for more time to prepare and claiming he had been denied access to his attorney. The judge denied the request and imposed the sentence. Despite offering words of sympathy to the Myers family, Eric Nos was led away to begin his prison term. He will one day be eligible to seek parole, but for the Myers family, the loss is permanent. Tashan Adams Wright. On December 23, 2022, 19-year-old Tashan Adams Wright, along with several others, confronted 19-year-old John Hudson inside the Mall of America during the busy holiday season. Hudson was tackled to the ground, and in the chaos, Wright and another individual opened fire. Hudson was struck multiple times and killed as shoppers fled in panic. One bystander was also hit by a bullet but survived. Within hours, Wright was arrested and charged with second-degree murder and second-degree assault. In court, he admitted guilt to both charges. Despite his young age, the judge emphasized the severity of the crime, calling it an execution carried out in a crowded shopping center filled with families and children. Hudson's family spoke about their grief, while Wright delivered an apology, acknowledging the pain he caused and blaming his actions in part on the influence of violent movies, music, and video games. The judge rejected any claim of self-defense, stating that Wright had participated in a group hunt that ended in murder. In May 2024, Wright was sentenced to 367 months in prison, equal to 30 years and 7 months. He was also barred from ever owning a firearm again, with restitution and fines imposed, and time already served credited. When asked for his final words in court, Wright said, "I want to apologize for the pain and suffering I caused. I know what I did was wrong, and I am sorry. But I understand that sorry is not enough." Judge Paul Scoggin then pronounced the sentence, closing the case of Tashan Adams Wright and the killing of John Hudson at the Mall of America.
In severance of the victim family, also to the lady got shot. And to the community of Lunacy in the Mall of America, also apologize for the mom and my family. After I was 18, I fully developed to really understand the impact of my actions. I know and understand what I did was wrong, but I accept full responsibility for my actions. I was saying I'm sorry, but saying I'm sorry is not only what I've done. I was influenced by false flag movies, music, and video games, but I cannot take back my action. I truly apologize for my actions. Thank you, Mr. Anderson.
So let me start by expressing my sympathies, my condolences for, as Mr. Hudson's aunt described it, the crushing grief that you have to live with every day. I can't wrap my head around this. No one who hasn't gone through what you're going through can. All I can do is acknowledge it. The pain, and it doesn't go away. And I understand that, and I'm truly sorry. I want to at least acknowledge the comment that family members made. I agree with it. It is remarkable that only 2 of the people who are involved in this matter will end up in front of adult courts. I think that's unfortunate, because it fails to recognize, and this I need you to hear, Mr. Adams Wright, that the criminal justice system must take into account the personal characteristics of the person who's in front of them. And I acknowledge you're young. But the criminal justice system also exists to punish people when they do bad things. And we forget that as a system at our peril. In crafting a sentence today, I've taken into account the remarkable circumstances of, in the middle of a holiday rush in a major retailer or a retail establishment, Mr. Wright, you and several others decided to hunt someone down and execute them. And we've all seen that tape. And there can be no other definition of what happened that day. And your recitation of acting in self-defense that day, you weren't. You participated in the group of people who killed someone. And it is as simple as that. And the sooner you wrap your head around that and understand that and acknowledge that, the better off you'll be. I do, I did make the findings, and I'll repeat them, that it was a group of 3 or more. We put a whole lot of other people in harm's way in addition to the guy that she killed. One of them was struck by a bullet, and there were children and loads of folks that deserved to be nowhere close to any of this they were involved in. So, taking that all into account, and taking into account your age, I've arrived at the following. Sir, you've entered a plea guilty to murder in the 2nd degree. You've also entered a plea guilty to assault in the 2nd degree. You've told me enough for me to believe you're guilty of those offenses, so I accept your plea of guilty. I adjudicate you guilty on both of those crimes. And starting with count 1, murder in the 2nd degree, I sentence you to custody of the Commissioner of Corrections for a period of 367 months. Against that sentence, you are entitled to credit for 524 days. Restitution is reserved for 45 days. $50 fine, $75 surcharge, and $3 library fee to be taken from prison earnings. You may never possess, use, transport firearms or ammunition or explosives for the remainder of your life. If you have not already done so, you must provide a DNA sample. As to the 2nd degree assault, that person has suffered a real harm in this. And I do not take a moment away from anything that the family of the deceased has told me. But I acknowledge at the same time that poor person had nothing to do with any of this and still took a bullet. So as to that sentence, I sentence you to the custody of the Commissioner of Corrections for a period of 6 months as provided by law. What I am doing today, however, I'll be frank, it is acknowledging your age, is making that sentence concurrent. So your sentence is 30 years and 7 months. So that is to be executed forthwith. Is there anything else for the restitution? Please stay. I did. Thank you. Thank you. This here. Thank you, Your Honor.
Demarquis Elkins. On March 21, 2013 in Brunswick, Georgia, 17-year-old Demarquis Elkins approached Sherry West, who was walking with her 13-month-old son, Antonio Santiago, in a stroller. After demanding money and being told she had none, Elkins pulled out a handgun and fired a warning shot. He then turned the weapon on Sherry, shooting her in the leg and grazing her head. In a moment that left the community and, later, the courtroom in shock, he walked to the stroller and shot baby Antonio in the face, killing him instantly. The case quickly drew national attention. At trial, Sherry West's testimony gripped the jury. She recounted how Elkins asked if she wanted him to shoot her baby, and how she pleaded for Antonio's life before he pulled the trigger. Elkins was arrested later that same day. His mother and sister were also charged for helping him hide the weapon. In court, jurors wept as they heard Sherry West's anguished words, and prosecutors played audio recounting the attack. On August 30th, 2013, a jury found Demarquis Elkins guilty on multiple counts, including malice murder, felony murder, aggravated assault, cruelty to children, and possession of a firearm. 2 years later, on February 12, 2015, Elkins was sentenced to life in prison without the possibility of parole. During sentencing, he showed no emotion and offered no words of apology. For Antonio's family, the verdict brought some measure of justice, but no sentence could erase the loss of a child. Elkins remains incarcerated, serving life without parole.
Tell us your name and spell it out for our court reporter, please.
Yes, Jennifer, Jennifer. Last name is Krauss, Krauss.
All right, Ms. Krauss, were you working as a registered nurse on March 21st of this year?
Yes, ma'am.
And did you treat a woman named Sherry West that morning? And did she tell you how she was injured?
Yes, ma'am.
What did she tell you?
She told me that she was shot. She said that she was walking down the road and she just said, they shot my baby and they shot me.
You remember writing what is called an adult assessment that morning about Sherry West, your ER notes from treating her?
I did write one. I don't remember exactly what it says. Ask me the question again.
What did Sherry West tell you as far as how she was injured based on the notes in your report?
Objection sustained. You have to, if that report, you read the report, if it refreshes your memory, okay, answer the question. You have to answer the question not from the report, but from your own recollection. So if that refreshes your own recollection, that's good, okay?
Yes. She did tell me I spent about 3.5 hours with her, so we kept, it was a continual conversation about what she had done that morning and that she was walking home from the post office and the baby was asleep in a stroller. She said 2 people walked up to her, 2 young boys walked up to her. She said she wasn't very concerned with it because she thought they were just coming to look at the baby. She's like, I thought that somebody was just going to come up and tell me how cute he was, and then they proceeded to ask for her money and her purse. She says, I don't have any money. I don't have anything in here. And they proceeded to shoot her, she said, in her leg. They asked again for the money. She said, I don't have any money, and that's when they shot him, the baby.
Recall her stating that a young child came up to her wanting her money?
Yes, she made the comment that her exact words that day were, they should have been in school.
They should have been as in?
They should have been in school. They were too young to be outside just roaming the streets at that time of day.
Ms. Krause, what was Sherry West's demeanor when you saw her that day in the hospital?
She was very distressed. When she came in, she was, they shot my baby, where is he, what's going on? She didn't know anything when she got there. She was very upset. And then I was in the room with her when the detective came in and we decided to let. When she came in, she was, they shot my baby, where is he, what's going on? She didn't know anything when she got there. She was very upset. And then I was in the room with her when the detective came in and we decided to let her know. Baby, they shot my baby, where I was in the room with her when the detective came in and we decided to let
that.
Just started crying and sobbing, and she was very upset.
Was she given any kind of medication for pain relief at the hospital while she was there for the wound in her leg?
I'm not 100% positive about that.
Okay.
She didn't say who. She didn't tell me who shot the shot, but she did mention say that someone had shot the shot.
You recall writing a trip report that morning for your treatment of Sherry West?
Yes.
Would seeing that report refresh your memory as to what she said that morning? Would seeing your report refresh your memory as to what you said that morning?
Well, I have my views.
Your Honor, he's not testified he's having any problems with remembering. He just testified that answered the question that she asked, and he's not indicated he's got any memory problems.
Just said.
Pardon me, address it to the court,
Just
please.
said he didn't know, she didn't say.
Ask your question again, if he can.
I said she didn't say who shot. She told me that somebody had shot. That's all she said.
Would seeing your report from that morning refresh your memory as to what she said as to who shot her?
He just testified from his memory. He doesn't need to see his report, Judge.
Is your memory better now?
Yeah.
Than it was on the morning of that shooting?
I'm telling you what she said. That's what she said. Somebody had shot her. She didn't say who shot her.
She didn't say who. She just said someone shot her. Is that? I understand what your answer is.
Someone.
Okay.
She didn't say who.
All right. Thank you, sir. I think you already did a little earlier, but can you say your name for the jury and then spell it out for our court reporter?
Raymond Marat. It's RAYMOND MARAT.
Were you working as a paramedic or EMT on the morning of March 21st?
Yes, ma'am.
2013?
Yes, ma'am.
And did you respond to a shooting at 708 London Street that morning?
Yes, ma'am.
Treat a woman later identified as Sherry West?
I didn't treat her. I walked up to her to talk to her.
Continue your answer.
I arrived on location, and at one point I walked up to her to see if I could offer aid before my other squad got there. And right as I approached her and asked her a question, then the other ambulance showed up.
Okay. Did she make any statements in your presence about how she was injured or how her child was shot?
Yes, she did. She stated they shot my baby.
That they shot my baby?
Yes, ma'am.
Do you remember writing a report that morning?
Yes, ma'am.
Do you recall reporting any statements about Sherry West and what she said that morning?
I refer to my report.
No, he's already testified to what she said. Why does he need to refer to his report?
Right, the law is you have to testify from your own recollection.
Oh, okay.
Okay, and you can refer to your report if you don't remember. Okay, and if it would help you refresh your recollection, you can't testify from your report, but if it refreshes, if you need to, you're certainly allowed to look at that and refresh your recollection. But then you have to testify from what you remember that morning. Okay.
Well, she made reference that she's walking down the street with her baby, and she was approached and her baby was shot.
Do you remember recording a statement that said mother was walking down the
Your Honor,
street?
she's now reading from a report that is not in evidence, and she's got a witness on the record.
Repeat your last answer, sir.
I'm sorry, ma'am?
You repeat your last answer.
She made reference that she's walking down the street with her baby, and she approached her and shot her baby.
Describe who this he was.
No, she didn't.
Juan Carlos Thorpe,
Where are you currently employed?
City of Brunswick, Brunswick Police Department.
And how long have you worked for the City of Brunswick Police Department?
Excuse me?
I'm sorry. How long have you worked for the City of Brunswick Police Department?
22 years.
22 years.
Yes, sir.
All right. Did you have occasion to respond on March 21st to the shooting of a young child?
Yes, I did.
Do you recall whether you were still on duty at approximately 18:45 hours, 6:45 p.m. on March 21st?
Yes, sir, I was.
Do you recall whether anyone approached you at that time?
Yes, sir.
What was the name of the individual that approached you?
Aldre Brooks.
He also known as Argy Brooks?
That's how you pronounce it, yes, sir.
Oh, well, I believe it's A-R-G-I-E, Brooks. I believe Officer Thorpe spells it A-L-G-R-E, Brooks.
Yes, sir.
And I guess only Mr. Brooks knows how it's actually supposed to be spelled. Sir, when Mr. Brooks approached you, was he in a car?
No, sir.
How did he approach you?
On a bicycle with no seat.
Is that an adult bicycle or a child bicycle?
Appeared to be a child bike. It was small.
Indicated that there was no seat?
Yes, there was no seat on the bike.
Did Mr. Brooks appear to be under the influence of alcohol or drugs?
To me, he did. Yes, sir.
Can you describe his present appearance and presentation to you at that time? I'm not questioning your observation. I'm just asking you to articulate for the jury why that appeared to be the case to you.
Well, when he came up to me, he was spewing saliva from the mouth, and he was kind of skittish. And when other people would walk by, he would clam up and wouldn't want to talk. And he just, to me, appeared to be high on something or alcohol.
Mr. Brooks stated that he needed money.
Yes, sir.
I don't want to cut you off. Did you want to object?
I was talking to my co-counsel. We may.
Did he tell you what he wanted the money for?
Objection, hearsay, Your Honor.
Your Honor, it's not a leading question. That's a yes or no question. That is not.
But the objection was hearsay.
He asked him to, did he tell you what he wanted the money for? That calls for a hearsay response, Your Honor.
As to hearsay, sustained.
Your Honor, Mr. Brooks is about to testify, but look, well, Your Honor, I have no further questions for you, Mr. Thorpe, but we'll keep him on standby. We'll recall him.
Do we have any questions from Mr. McElvain?
Jarvis, would you please state your full name for the record?
My full name is Francis Thomas Jarvis, but I go by the nickname of Jay.
Very well. Mr. Jarvis, where do you live? What part of town do you live in?
Well, I live just outside of Rome, Georgia.
Born in Georgia?
No, sir, I wasn't. I think my accent probably gives that away.
Well, where were you born?
I was born in Long Island, New York.
Very well. Did you attend college?
Yes, sir, I did.
Where did you attend college?
I received my undergraduate degree from Georgia College in Milledgeville in 1978. Then went on to the University of Pittsburgh, where I received a master's degree in forensic chemistry in 1979.
Is that an MS?
Yes,
Master
sir.
of Science?
Master of Science, that's correct.
Did you subsequently obtain another degree?
I also received a degree, a master's in public administration from Georgia State University, I believe in 2006 or 7, can't remember.
Is that Columbus? You say Columbus? Is that Columbus State University?
Did I say Georgia? I'm sorry, it was Columbus State University in Columbus.
Did you subsequently perform an internship?
Following my, as a part of my graduate studies at the University of Pittsburgh, I did internship at the Allegheny County Crime Laboratory, which is located in Pittsburgh.
And where have you held any positions in the scientific field?
Yes, for approximately 32 years I was employed at the Georgia State Crime Laboratory. I worked both here in the Atlanta office. I also worked in the laboratory in Macon, as well as a Northwest Georgia laboratory that was located in Somerville.
You started with the GBI in what year?
In September of 1979.
You retired in what year?
I retired June the 1st, 2011.
We would stipulate to Mr. Jarvis's point.
Is that stipulation, Mr. Grove?
Do you, Your Honor?
Okay. I find he's an expert and allow him to give opinion and testimony thereof.
Mr. Jarvis, have we met before?
Not prior to right now, no, sir.
All right. But we have communicated by phone?
Yes, we have.
Were you retained by the defense, Mr. Elkins, to look at some of the evidence in the State v. Elkins case?
Yes, I was.
And were various items of evidence sent to you for your review?
There were documents sent to me, and then I actually physically went to the crime laboratory located in Savannah to examine other items of physical evidence.
So in addition to reviewing documents related to the case, you actually physically went to the crime lab yourself?
Yes, sir, I did.
And you actually physically reviewed the evidence, physical evidence, the bullets, shell casings, gunshot residue kits, everything at the crime lab in this case?
Yes, sir, I did.
Were you asked to, well, before I get there, do you know Brian Leopard?
Yes, I do.
How long have you known Brian Leopard?
I've known Brian since he was first hired, and I'm not sure what date that was, but you know, it's a small community of people that do firearms and ballistics work in the state, so everybody knows everyone.
And you were specifically asked to review his reports?
That's correct.
Okay. Do you recall the nature of, or the kind of weapon involved, held in evidence in this case?
Yes, it was a RG Model 14 .22 caliber revolver.
Okay. Does that gun fall in a class of weapons that has a special nickname?
It's commonly referred to as a Saturday Night Special, which is an inexpensive, cheaply made firearm that usually sells for less than $100.
All right. Do you recall being asked to review the available data as to how many of those weapons were manufactured?
Yes, sir, I do.
All right. How many of those weapons were manufactured?
Of that particular model, there were over 800,000 of that particular model manufactured.
Now, Agent Leopard, in his report, identified several manufacturers of similar guns.
That's correct.
And similar, I'm sorry, it's not truly a scientific phrase. When you're examining firearms, can you explain to the jury what it is that you're looking for?
Certainly. In order for a firearm to fire a bullet and for the bullet to travel in a straight line and for the firearm to be accurate, the bullets have to have a gyroscopic spin as they come out of the end of the barrel. If you can if I can use this as an example, when you think about a football being thrown, in order for a quarterback to throw a football in an accurate manner, he has to impart a spin to the ball when he throws it. Otherwise, it will tend to just tumble through the air instead of firing in an accurate manner. And the same holds true for a bullet. If the bullet is not spinning about its axis when it comes out of the barrel, it tends to tumble, and it won't fly in a straight line, and the firearm is not accurate. So in order to cause that bullet to have a spin about it, the manufacturers of the firearm barrels create what's known as rifling. And what rifling is a series of ridges that are inside the barrel that are left in there, and the process is done so as the bullet engages these raised ridges, it will impart a spin to the bullet. So when it actually comes out of the end of the barrel, it's spinning about its axis, and that allows it to fly in a straight direction. Well, different manufacturers utilize processes that put different numbers of lands and grooves, and it's the raised areas, the raised ridges in the barrel that actually grip the bullet and impart the spin to it. So you may have one manufacturer that may put 4 or 5 lands and grooves, and you may have one that may put as many as 20. It's kind of a manufacturer's preference.
The revolver that you examined at the Georgia Crime Lab, how many lands or grooves did it have?
That particular model has 8 lands and grooves.
And what does it mean to say that the barrel has a twist to it? I mean, they're all straight in one sense.
Yes, but when the grooves are cut in or formed in the barrel, the tool has to be rotating as that forming process is done, and that's what allows the bullet, when it engages with the rifling, to begin to turn. So some manufacturers, very few, use a left-hand direction of twist, but the majority of them use a right-hand twist.
All right. And this particular revolver was in the majority that used the right-hand twist?
Yes, sir, that's correct.
Now, we've all watched CSI and other shows on television. Is it always possible to tie a particular gun to a particular spent bullet? Is that always possible?
No, it's not always possible, no, sir.
In fact, it's often not possible.
Well, I would say it's, I don't know that I would use the word often, but it happens more frequently than you probably would believe.
And for some calibers, some kinds of firearms, it happens more commonly than with others.
That's true, and also with certain types of weapons, it happens more frequently.
And in this case, having reviewed the items, I think they were, as referenced in the crime lab report, you examined how many bullets?
A total of 2 fired .22 caliber lead bullets.
And the condition of those bullets was not ideal?
They were not ideal. It was easy to discern that the bullets were .22 caliber, but approximately half of the bearing surface that bears the markings that we would use to make a comparison were unsuitable for comparison.
So beyond looking at the twist of the grooves, twists of the lands and marks and their number, did you really have any other basis to make comparison with the evidence available?
No, sir.
And on that basis, were you asked to go back and look at the manufacturers that may have manufactured guns fitting these characteristics?
Yes, I was.
All right. Now, in addition to those identified by Mr. Leopard, you were able to identify several more, were you not?
Yes, I put together what I would say was a more comprehensive list of firearms that were produced that had rifling that was similar to what I observed on the bullet.
Can you identify those manufacturers for the jury?
I certainly can. 22 caliber revolvers that have the same 8 lands and grooves with a right-hand twist include the RG, which is what I examined, Arminius, Burgo, North American Arms, Herbert Schmidt, Hawes, Valor, EIG, which is spelled E-I-G, Kimmel, Gekado, Liberty, Dixon, PIC, Bison, Fab Arm, and High Schooler. There are...
Hold on a second.
Okay.
Those manufacturers, all of those manufacturers manufactured revolvers or just handguns?
These were all just, these are just the revolvers that have the same rifling.
In 22 caliber?
Correct.
Now, are there other weapons that also fire 22 caliber long rifle rounds with the same number of grooves and the same twist?
Yes, there are two manufacturers of Derringers, the RG, which is the same manufacturer of the weapon that I examined, and also American Firearms. And then there's also several rifles that include Mossberg, Revelation, Western Field, Cooey, Lakefield Arms, Etonia, and Lithgow. And then there were 2 pistols, the Lorson and Intratec, that also have the same type of rifling.
All right. Do you have an opinion as to how many weapons, how many 22 caliber revolvers were manufactured that would have the same characteristics in terms of groove and twist?
Well, just based on the fact that the RG-14 model had over 800,000 that I'm aware of manufactured, I would estimate that given all the other manufacturers that I named off, I would guess that it would have to be in the, at least a couple of million.
Well, to be fair, let me rephrase the question.
Chad Dorman, June 15, 2023, in Claremont County, Ohio, 32-year-old Chad Dorman shot and killed his 3 young sons, Clayton, Hunter, and Chase, at their home. His ex-wife, Laura, and stepdaughter, Alexis, were also injured in the attack. Authorities say Dorman carried out the murders in front of them before being arrested without incident later that day. He was charged with 3 counts of aggravated murder and 2 counts of felonious assault. Dorman initially faced the death penalty, but in 2024 accepted a plea deal ensuring he would spend the rest of his life in prison without parole. Prosecutors said the agreement spared Laura and Alexis from having to testify and relive the events. Laura supported the decision, writing in a letter that ending the case this way was best for her family. In court, Alexis addressed Dorman, saying she had once trusted and looked up to him as a father figure, and that she would never get another day with her brothers.
Because it hurts to know I will never get to experience another day with my 3 brothers.
Laura described fighting with all her strength to stop the attack, yet living with the pain of not being able to save them. Dorman declined to make a statement, but his attorney claimed he was in a delusional state and suffering from psychosis at the time of the killings. On the day of sentencing, Dorman stood before the judge and pled guilty 5 times. He was sentenced to life imprisonment in an Ohio state facility with no chance of release. Andrea Bradley. In 2015, 28-year-old Andrea Bradley brought her severely malnourished 2-year-old daughter, Glenara Bates, to Cincinnati Children's Hospital, where doctors confirmed the child was already dead. An autopsy revealed that Glenara had suffered prolonged abuse and neglect. Prosecutors described her condition as unimaginable. Bradley was charged with aggravated murder, but due to an IQ in the 60s, the court ruled she was ineligible for the death penalty. After negotiations, she accepted a plea deal. The aggravated murder charge was dropped, and she pleaded no contest to other related charges. Nearly 3 years earlier, Glenara and her siblings had been removed from the home by Child Protective Services, but were later returned, a decision that would have devastating consequences. While Andrea Bradley's case moved through the courts, the trial of Glenara's father, Glenn Bates, resulted in a jury finding him guilty of aggravated murder. He was sentenced to death for his role in the killing. During her plea hearing, Andrea Bradley quietly answered the judge's questions, acknowledging that she understood the charges and the agreement. When asked if she had anything to say for herself, she offered nothing. The prosecutor later stated that the abuse Glenara suffered was beyond comprehension, and that some people should never be parents, period.
You do have to accept the reality that there are just some people that should never have kids, period. And our challenge is, under the federal and state guidelines that want us to reunite families, is to identify the people that shouldn't be parents and get them out of the house.
Bradley remains in prison, serving her sentence for the crimes that contributed to her daughter's death. Shaun Allen. On August 14, 2023, 37-year-old Shaun Allen, after an argument at a nearby bar in Akron, Ohio, drove his SUV down Cross Street, where 40-year-old Lee was pushing his infant daughter in a stroller. Investigators later stated that Allen deliberately targeted Lee, steering his vehicle toward them and striking both father and child. Lee and his daughter died at the scene. During sentencing, the courtroom was filled with family members holding a large picture frame filled with photos of their loved ones. Several took the stand to speak directly to Allen. Prosecutors described Allen as showing no remorse for the killings. Court heard emotional statements like, "We have nothing but memories. We have nothing but screenshots and posters. And he chose to hunt them down like dogs."
We have nothing but memories. We have nothing but screensavers and posters we have for kids.
He chose to hunt them down like dogs. Why is he eligible? Life is life. By law, he needs to die. You got 6 kids, and you okay to sleep at night knowing you ran down a baby and ripped her from a stroller?
Allen was convicted of 2 counts of aggravated murder and sentenced to 2 consecutive life terms, plus 3 additional years. He will be eligible for parole after serving 63 years. Lee's family expressed that no sentence could truly match the loss they suffered, and that Allen has shown no sign of regret since the day of the killings. Lovely Johnson. On the morning of her trial, 23-year-old Lovely Johnson, charged with the child neglect murder of her young son, rejected a plea deal that would have given her a minimum of 15 to 25 years in prison. Instead, she chose to face a jury, risking the possibility of life in prison without parole if convicted. Earlier that summer, while Johnson was being held in jail awaiting trial, staff members opened a letter she had written to her attorney, copied it, and forwarded it to Wyoming police. The right to confidential communication between a defendant and their attorney is a cornerstone of the American justice system, and in this case, that principle was breached. Jail officials claimed the letter was opened by mistake. Wyoming police said that as soon as they received it, they forwarded it unread to the Kent County prosecutor, who also confirmed it was never read.
The last thing we want to do is violate anyone's rights, and by breaching that attorney-client privilege, we are doing that.
The incident was brought before Judge Mark Trousseau, who warned jail officials that such conduct must never happen again, or there would be contempt consequences.
This is not to happen again out at the jail, or there will be contempt issues.
In court, Johnson's defense requested more time to investigate the handling of the letter, suggesting this was not an isolated incident, and that similar breaches may have occurred in the case of Quinn James, a defendant accused of murdering a teenage girl.
I would say it's almost insane to say that we can't even have a week or 2 weeks to find out, was it appropriate what happened with her letters to me?
And if these mistakes are able to happen on 2 murder cases in less than a month, that's a problem. I'd like to see the jail do a complete investigation about how many letters were opened and copied and sent to police and prosecutors.
The judge denied the request for delay, and the trial moved forward. Maintaining her innocence, Johnson now faces the full weight of the charges against her.
This was a outrageously disturbing set of facts, ma'am. This was your own child who was 6 months old, and you killed him. You left this child alone, you mistreated this child, and then what did you choose to do? You went out with your friends, you partied, you sought out a place that had air conditioning, and you used drugs.
So do I think that she has the heart and soul of someone who wanted to torture her and sadistically murder her baby? No, she doesn't. She was a kid that made some horrible mistakes. So I think that would, the court would be justified in a downward departure.
If I could give my life for his, I would have done that.
I hope you think every day of how you killed your own child, ma'am. Ma'am, I hope every day you think about what you did and about the life that you took away. We're done here. Take her to prison, please.
Thank you, Judge.
Jacob Bumpass. In September 2010, 17-year-old Paige Johnson vanished without a trace after spending time with 22-year-old Jacob Bumpass in Covington, Kentucky. Bumpass, a friend of Paige's, told police he had dropped her off at an intersection, but she was never seen alive again. For nearly a decade, her family searched relentlessly, hanging posters, appearing on television, and pleading for any information. Then, in 2020, their worst fears were confirmed. Paige's remains were discovered in a wooded area in Claremont County, Ohio. Investigators determined that Bumpass had concealed her body and tampered with evidence to cover up the crime. He was charged with abuse of a corpse and tampering with evidence. At trial, prosecutors highlighted the trust Paige had placed in Bumpass and how that relationship made the offense possible. The court noted his prior criminal history, including multiple theft convictions, and deemed his actions the worst form of both charges. The judge condemned the deliberate disposal of Paige's body, which prevented authorities from determining her cause of death, and described the tampering as a 10 out of 10 in severity.
The court will consider that along with the victim impact statements that I received from Ms. Haywood and Ms. Johnson. The court has, in anticipation of today's sentencing, reviewed and considered the purposes and principles of felony sentencing. I've certainly presided over the trial, the entirety of the trial. I heard the evidence firsthand. I'm considering that as well as I sentence you, Mr. Bumpass. Identifying what I've reviewed, certainly the pre-sentence investigative report, the victim impact statement, letters that have been received from family members. Looking at the purposes and principles of sentencing, first thing I have to look at is Mr. Bumpass's prior criminal contacts, if any, and he does have criminal contacts as an adult. Back in 2007, he was convicted of theft by unlawful taking in Kenton County, Kentucky. Ultimately, it appears that he was convicted of that offense in 2007. In December of 2007, there was a robbery offense, which was reduced down to a theft by unlawful taking. And he was sent to prison in Kentucky. So that's the first Department of Corrections number he has. So he served a prison term previously on that. And in 2008, November of 2008, another theft by unlawful taking charge where he was incarcerated in Kentucky prison on that as well. So the record reflects two separate prison numbers, two separate prison stints for Mr. Bumpass. So he's committed prior criminal acts and he served prior prison terms. The court has to look at the offenses to determine whether they are the seriousness level of them. Not obviously any felony is serious, but the legality of, there's a legal terminology, if you will, in regards to seriousness factors. Statutory language that the legislature gives us, there's certain factors the court has to look at to see if an offense is more or less serious than conduct normally constituting the offense or offenses that typically occur. As far as serious factors under 29-29-12, after reviewing those, the court is going to find that the offense, certainly both offenses in my opinion, are more serious than conduct normally constituting the offense. One of the factors is certainly relationship that you had with the victim here facilitated the offense. This is someone that you were friends with at the time of the commission of the offenses, that trusted you, and your relationship facilitated the offenses in the court's opinion. Other relevant factors as to whether the conduct is more serious, I would observe that, and I would agree with the state, that these are both the worst form of the offenses. And as far as tampering with evidence goes, I see a lot of tampering with evidence charges. Typically that's somebody hiding,
contraband or drugs or something like that on the floorboard, throwing it out the window. This is on the whole other scale. This is you secreting certainly a body as potential evidence against you. So this would be, on a scale of 1 to 10, this is the 10. This is the absolute worst form of a tampering with evidence charge that I have seen through my experience. As far as the abuse of a corpse, you don't see a lot of these type of cases, but they do exist where someone's taking pictures of dead bodies in the morgue or whatever it may be. This would be on the other end of that spectrum. Here, this is you disposing of Paige Johnson's body in a manner, I think it was described as disposing her like trash by the prosecutor. So that's exactly what we have here. As an abuse of a corpse, I think this would be the worst form of that offense as well. And certainly your efforts to tamper with that body and that evidence precluded certainly law enforcement from determining any type of cause or manner of death. So I think it's the worst form of the offenses. As I see your prior criminal history, Mr. Bumpass, I see an escalation in criminal conduct. You go from theft-related offenses, where you went to prison on this, to these type of offenses, which in my estimation are much, much more serious. So there's an escalation of criminal conduct. Recidivism factors under 292912D, that is his likelihood to reoffend. I would find that recidivism on whole is more likely. At the time that you committed the offense, you were under release from confinement. Specifically at the time of the instant offense, you were on post-release control and or parole through Kentucky authorities. So under their supervision, you committed these offenses, which makes recidivism more likely. You, as I alluded to, have a prior history of criminal convictions, and you've had other contacts with other courts that did not deter you from committing this offense. In other words, you've not been rehabilitated to a satisfactory degree prior to committing this offense, and you've not responded favorably to sanctions previously imposed for other criminal convictions. Last, but certainly not least, as far as the recidivism factors, the court finds that you show no genuine remorse for your conduct. The count 2 is a felony of the 5th degree. The court will certainly overcome presumption for community control or probation. This involves, again, I believe, the worst form of the offense. And you committed this offense while you were serving or under previously sanctioned from a prison term on parole. And you've committed that offense while under sanction from parole, and you've previously served a prison term, which allows the court to overcome a presumption for prison on a felony of the 5th degree. Certainly the pain, suffering to the victim's family is unmeasurable. For many years, you've avoided the consequences of your actions. We've heard that said today, and I think that is certainly true. The courts considered the purposes of principles of sentencing, including the minimum sanctions necessary to accomplish the purposes of sentencing without imposing an unnecessary burden on state and local government resources. Just so the record's clear, I'm finding that the offenses both are more serious than conduct normally constituting the offense, and recidivism is more likely. I'm finding that prison is consistent with the purposes and principles of sentencing, that community control is not, and you're not amenable to available community control sanctions. Ms. Haywood, when she began her statement this morning, and had a quote from Dr. King. It's actually, he's quoting I can't offhand tell you who it is, but it's an older quote from an old jurist, and it's an old proverb, if you will, or saying in the law that justice delayed is justice denied, and that is certainly the case here. Ms. Johnson's family's waited, I think, 13 years for you to be brought to in front of a jury of your peers. What struck me, I guess, listening to the evidence was the callousness that she showed and the indifference, lack of compassion. And the best, I think, example of that was the testimony of Ms. Johnson, where as the mother of a child who's been missing for less than 48 hours, you're the last person seen with her. She goes to your home to inquire, hey, you're her friend, have you seen my daughter? And you slam the door in her face. Doesn't get much more cold-blooded and callous than that, Mr. Bumpass. No empathy for what happened to Paige, no empathy for the family, no concerns for Paige's body or her remains. This is a friend, somebody that trusted you that evening. We've certainly escaped punishment for, I think, 13 years. But what's clear now is that everyone sees you, knows the truth, and knows what you did. I have to sentence Mr. Bumpass within the bounds of the law. The law here, there's a tampering with evidence charge, which carries a maximum 36 months in prison, and the abuse of court charge carries a maximum prison term of 12 months. So 4 years is the maximum that I am allowable or permitted under the law. If these crimes don't warrant the maximum term, I'm not sure what does. 4 years maximum possible penalty certainly does not equate to the severity of your actions and the harm that you've caused to Ms. Johnson's family, to the community. But I don't make the law. I enforce the law. And I'm going to impose the maximum penalty that I can impose in this circumstance. In doing so, I'm going to find that prison is consistent with the purposes and principles of sentencing, that on count 1, you will be ordered to serve 36 months in the Department of Corrections. On count 2, you'll be ordered to serve 12 months in the Department of Corrections. You will serve those consecutively for an aggregate prison term of 48 months or 4 years. In order to impose a consecutive sentence, I have to make findings, which I'll do so at this time. The court finds that consecutive sentences are necessary to protect the public from future crime from you and to punish you. That consecutive sentences are not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. Consecutive sentences are necessary to protect the public from you. You are highly likely to commit future crime given your history of criminal conduct, lack of remorse, the danger you pose to the public, and certainly the manner, the callousness of the crime, I think. So certainly consecutive sentences are necessary to protect the public from future crime, which looks primarily at your prior criminal history, and I see an escalation of criminal conduct there. It's not disproportionate to the seriousness of your conduct and the danger you currently pose to the public. The court finds further that you committed one or more of these offenses while under post-release control for the felony offenses in Kentucky. You're on parole in Kentucky when you committed these offenses. In addition, at least 2 of the multiple offenses committed here as part of one or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of the course of conduct would adequately reflect the seriousness of your conduct. These are separate individual criminal acts with different harms involved. To run these concurrent or together would demean the seriousness of the tampering with evidence charge and the separate abuse of corpse charge. And finally, you have a history of criminal conduct that demonstrates that consecutive sentences are necessary to protect the public from future crime by you. In imposing the consecutive sentence and the maximum sentence, the court has considered the aggregate term here of 48 months, which is certainly proportional to the crimes here, the harm caused, the necessity to protect the public. The case law the court's guided by, I have to look at the aggregate sentence, consider the number of sentences that I'm imposing consecutively. Consecutive sentences are necessary, again, to protect the public. It's dependent on your criminal history, which certainly demonstrates the need for you to be incapacitated for a lengthy term of incarceration. Each sentence on individual account should be imposed consecutively, and I have considered the aggregate term. I've made the necessity findings that I believe I need to make. I've considered the overall prison term when imposing that. Imposing consecutive sentences, I have considered each sentence on individual counts that I intend to impose consecutively on you and the aggregate term that will result. So I've considered the necessity, I've certainly considered proportionality, and the aggregate term that I'm imposing for 48 months. He gets credit for 48 days that he served. Mr. Zipper, my hope is that you discuss with Ms. Johnson, Ms. Haywood, why the court cannot imposed the restitution amounts that were requested?
I have, Your Honor.
Okay, very good. And then for those reasons that there's lack of verification, the court can't impose it. I will not be imposing the restitution that's being sought by them in the pre-sentence investigative report. Court costs will be imposed. Post-release control when you're released from prison, Mr. Bumpass, is optional up to 2 years. If you violate that post-release control, the parole authority could return you back to prison for up to 9 months for each violation, up to a maximum of half of your original sentence here. If you're convicted of a new felony while you're on post-release control, in addition to any prison term imposed for the new felony, you could receive an additional prison term of the greater of 1 year of the time you still have remaining on post-release control. You are now ordered to serve as part of this sentence any period of post-release control imposed by the parole board and any prison sentence imposed for a violation of that post-release control. Court cost will be imposed. You certainly have the right to appeal. You're well aware of that. The conviction and the sentence of the court, if you're unable to pay for the cost of appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be afforded without cost to you as well. If you're unable to pay for the cost of documents necessary for an appeal, they'll be provided without cost. And you have the right to have notice of appeal filed timely on your behalf. The final thing I would indicate certainly is that, let me ask, Mr. Zipper, on behalf of the state, anything I omitted or failed to advise Mr. Bumpass on?
I don't believe so, Judge.
You know, the courts, if I had a magic wand, certainly, I see the pain throughout the trial of the Johnson's family. Certainly we're all human beings involved in the system. I'm sentencing you, Mr. Bumpass, based upon the law and what you did alone, without concern, if you will, in regards to that. The court has to approach that in a very methodical way but certainly the court understands can't understand the pain, but I understand the circumstances here. And my hope is that the family of Ms. Johnson is able to find some peace now. Her remains have been recovered. Now Mr. Bumpass has been sentenced to the maximum, to the fullest extent of the law that I can impose. So my hope is that they find some peace going forward. With that, he is committed to the custody for imposition of his 4-year prison term. Anything in addition, there's court cost, obviously restitution for obvious reasons is indicated. I can't impose that. He gets credit for, I think, 48 days served. Anything that I missed?
I think you've covered everything, Judge.
Mr. Serkin, you're filing, I think you're filing maybe an appeal. Anything that you need to make on the record before he is committed to the custody of the sheriff?
During sentencing, Page's family delivered a powerful victim impact statement, speaking of years of anguish, their father's death from a broken heart, and the toll on Page's young daughter, who was only 2 years old when her mother disappeared. They expressed anger at Bumpass's complete lack of remorse or accountability. On August 24, 2022, Jacob Bumpass was sentenced to 15 years in prison. In court, he offered no apology, no explanation, and no acknowledgement of the pain he had caused. Page's loved ones left knowing justice had been served in law, though never in their hearts.